So, I hope you are all okay. You must have heard a proverb that himmate marda madade khuda. If you do not dare, you cannot succeed. If you do not make efforts, you will never succeed. So let us try our level best till the point we can do it. If it becomes really uncontrollable, then obviously you don't have any option available, you will have options choice, you can't do anything. Then you will have to take rest, you can't do anything. But I'll try my level best. So let us continue. I wanted to do questions today, but due to this reason I am deferring it, because that requires energetic effort and very cool mind and comfortable state of mind. So, this is really wonderful that you all have responded to my query. So my question is, please let me know whether you are comfortable in understanding the concepts, the theory at least, and its I also talked of answer writing, and I said at least you can write law on the point. As far as application part is concerned, I will make you comfortable regarding that. But there is one request from my side. Please don't be disheartened if you do not understand anything. Don't lose hope. It is said, no defeat is final unless you stop trying. So, never stop trying. A human being can do wonders. People like me and you create huge empire. People like you and me do wonders. Einstein was also like us. He was the same Albert Einstein. About whom the class teacher said that this boy is not fit to be kept in this school. He's so pathetic. He is so poor. And he wrote a letter to his mother. Obviously, a mother will cry on this. Similarly, any one of you who doesn't understand anything would feel like disheartened. But this is not the way to succeed. This is not the way to achieve something greater. If I do not understand anything, I reread it. I read it after some interval. I try to study it again, I try to apply my mind again, and then I find that, oh, I left this. It happens with me many a times that I may not understand a point in one go. It may be, now, have you ever analyzed what are the reasons behind not understanding a concept? It may be due to your concentration, that you are not able to pick finer points, finer arguments. It may be due to lack of commitment, that we are not sincere enough for our efforts. It may happen with me. It may happen with you. It happens with anyone. So if you do not understand anything, please don't lose hope. जैसे किसी को अंग्रेजी कम समझ में आती है, जैसे किसी को केस लॉ कम समझ में आता है. There may be many people who may be weak in English, there may be many people who may be weak in reading case laws because they have never read case laws. There may be some people who have never read Bare Act in such a way. So it may be a new experience for them. We are being exposed to a new kind of learning pattern. We are using too much cases. Sometimes I am explaining the case in great detail, sometimes I am quoting the ratio. So there may be some gap between your understanding and my communication. There we are required to fill the gap. It can be done by your effort, my effort. So please go through it, devote time. There is nothing which you cannot understand. Every one of you. I am talking to each one of you. And those people who have problem in English, they should try to improve it a little bit. Every day if you read a page in English, every day if you listen to news in English, every day you read a newspaper, news item on law, you will keep on improving English. And this is the way to learn. Don't lose hope, please, for God's sake. Everybody can learn anything. आप में से हर विद्यार्थी हर कुछ समझ सकता है, सिर्फ प्रयास करना होगा. मैंने आपसे आज 2 सवाल पूछे जो आपके स्क्रीन पर लिखा है. आप मुझे बताएं कि क्या आपको चीजें समझने में सहूलियत है, सुविधा है? नहीं है तो आपको पढ़ना होगा, थोड़ा मोड़ा प्रयास करना होगा. आप प्रयास करेंगे तो सीख जाएंगे. मैंने आपको बहुत आसान सा तरीका बताया. जैसे देखो, मैं आपको एक समरी बताता हूं. हमने स्टार्ट की स्टोरी प्लेंट से. मैंने पहले आपको प्लेंट लिखने का तरीका बताया. मैं थोड़ी हिंदी में बोल लेता हूं. द पीपल हु डू नॉट अंडरस्टैंड हिंदी, दे विल हैव लिटिल बिट पेशेंस बिकॉज आई विल बी स्पीकिंग एवरीथिंग इन हिंदी राइट नाउ फॉर फ्यू मिनट्स एंड देन आई विल स्पीक अगेन इन इंग्लिश विद लिटिल बिट डिफरेंस. So I'll speak the same thing in English again. So please have little bit patience and let me speak little bit in Hindi for those people who do not understand English well. So मैं कह रहा हूं कि आपको मैंने कुछ कॉन्सेप्ट पढ़ाए. सबसे पहले मैंने वाद लिखने का तरीका बताया, वाद पत्र लिखने का तरीका बताया, जिसको हम लोग प्लेंट कहते हैं. मैंने आपसे कहा कि आप आदेश संख्या 6, आदेश संख्या 7 का अध्ययन करें. आदेश संख्या 7 में बहुत सारे रूल हैं, आदेश संख्या 6 में भी बहुत सारे रूल हैं, बट अभी सब रूल आप नहीं पढ़े हैं. लाइक आदेश संख्या 6 में रूल 16 है, 17 है, वो अमेंडमेंट ऑफ प्लीडिंग से रिलेटेड है. सिग्नेचर एंड वेरिफिकेशन आपने पढ़ा था. ऑर्डर 6 के रूल 14, 15 में वो आपने पढ़ा. आपने शुरुआत के कुछ उसके रूल्स पढ़े, कुछ छूटे भी होंगे. मैं फिर से उसको बताऊंगा जब भी मौका मिलेगा. कहीं ना कहीं वो आ जाएगा, इसलिए आप धैर्य रखना. ऑर्डर 7 की सब चीज़ आप लोग लगभग पढ़ चुके हैं, तो आपको समझ में आ गया होगा कि प्लेंट लिखने में ऑर्डर 6 एंड ऑर्डर 7 का हमें ध्यान करना है. बट आपको भरबेटी में चीज़ें नहीं सीखनी है. शब्द बाई शब्द आपको चीज़ें नहीं सीखनी होती है, आपको उसका भाव पकड़ना होता है. सब्सटेंस हैज टू बी अंडरस्टूड. So if you have understood the substance of order 6 and 7, I think you have understood how to write plant. So that is not a big task. So I said, I am speaking for English speaking people. So I said that we started our journey from plant writing and plant drafting, where we learned that how order 6 and 7 will be brought in action in writing the plant. And it was very commonsensical approach. ऑर्डर 7 का रूल 1 पढ़ा आपने, ऑर्डर 7 का रूल 2, 3, 4, 5, 6, 7 ये सब पढ़ा आपने, 8 तक पढ़ा आपने, उसके बाद 9 से फिर थोड़ी सी कहानी अलग हो गई। तो ऑर्डर 7 का रूल 1 to 8, ऑर्डर 7 का रूल 1 to 8 प्लांट लिखने में मददगार होता है, और ऑर्डर 6 का रूल 1 to 15 लगभग लगभग आपने उसको थोड़ा देखा होगा, नहीं देखा है तो उसको एक बार जस्ट बैठ के देखना। हर चीज पहले बार में समझ में आ जाएगी ऐसा नहीं है। So my request is to all that you please read order 6 and order 17, order 7 rule 1 to 8 and order 6 rule 1 to 15. So you please read them at home. I have told you little bit, you can do little bit more. So there is nothing very big in this. Then I said that when you write the plant, then you are required to see the parties. So order 1 deals with party. Now there can be multiple parties on both sides. दोनों तरफ में बहुत सारे लोग हो सकते हैं. So multiple parties basically now will require joinder of parties. यानी उसमें व्यक्तियों का संयोजन होगा, वादियों का संयोजन होगा, प्रतिवादियों का संयोजन होगा, यानी वादी प्रतिवादी दोनों के तरफ से कई लोग आ सकते हैं। उसी में एक संकल्पना आई थी रिप्रेजेंटेटिव सूट की, चूंकि मैं उसको 2 मिनट नहीं बता पाया तो कुछ लोगों को असुविधा हो रही थी, तो मैं उनके लिए कल भी बताया, कोई ऐसी असुविधा वाली बात नहीं है। देयर इज नो डिफिकल्टी इन ऑर्डर 1 रूल 8 रिप्रेजेंटेटिव सूट, जो मैंने नोट्स लिखा है। न्यूमरस पीपल होने चाहिए, देयर शुड बी न्यूमरस पीपल, देयर शुड बी कम्युनिटी ऑफ इंटरेस्ट, anyone can file the suit as a representative of all, but all's interest should not suffer. That is why there is a requirement that you will give notice to all, and then you will take permission of the court. And if it is found that somebody is not acting well on behalf of all, then you can intervene also. You can make a request to the court that I should be impleaded in it, and the court will implead you, because court thinks, and the person who is representative, he is not allowed to withdraw the suit, he is not allowed to relinquish any claim, he has to take permission of others also, because it is others' interest also. But once decision is given even in representative suit, it will bind all the parties, it will operate as res judicata also. So that is the crux of order 1 rule 8. मैं आपको शॉर्ट नोट्स उस पे लिखा है, आप प्लीज उसको पढ़िएगा। और भी कोई पॉइंट छूटे हैं ना उसके, तो व्हेन विल सॉल्व द क्वेश्चंस विल ब्रिंग मोर पॉइंट्स, डोंट वरी, विल सॉल्व द क्वेश्चंस आल्सो। 1-2 दिन में क्वेश्चन हम सॉल्व करना स्टार्ट कर देंगे, तो हम ऑर्डर 6, 7, 1, 2 सभी के सवाल सॉल्व करेंगे। हम एक बार ना 2-4 टॉपिक पढ़ाने के बाद सवाल सॉल्व करना शुरू करेंगे, ऑब्जेक्टिव सब्जेक्टिव दोनों। सो प्लीज डोंट वरी फॉर दैट, हैव पेशेंस, थोड़ा सा धैर्य रखेंगे। हम ऑर्डर 6, 7, ऑर्डर 1, ऑर्डर 2, ऑर्डर 4 में तो कुछ है नहीं ऐसा, हम सबके सवाल बनाएंगे। सो इफ आई हैव लेफ्ट एनीथिंग, सो आई विल बी कवरिंग इट देयर, सो डोंट वरी रिगार्डिंग दैट, विल कवर ऑल द क्वेश्चंस देयर। इज दिस क्लियर? सो यू शुड नॉट वरी एट ऑल. So we'll be solving the question of order 6, order 7, order 2, order 1. तो आपको परेशान नहीं होना है उसके लिए। देखो परेशान होने से कोई आपको फायदा नहीं है। Is this clear? So we should not worry at all. अब आगे की ओर चलते। अब मैंने ऑर्डर 6, 7, 1, 2 and order 4 also. Order 3 has nothing, recognized agents and plants, recognized agents and pleaders. So you have read order 1, order 2, order 3, order 4, order 6, order 7. Now your plant is ready, as I said even yesterday. You have dealt with the plant. Now see, this whole journey is journey of hurdles. जैसे आपको बहुत सारे hurdles आ रहे हैं ना, ये नहीं समझ में आया, वो नहीं समझ में आया, I could not understand this, I could not understand that, or you could not solve one question, or some concepts have been left in the class. All these questions will arise. Even if I teach you order 2 for 10 days, there will be one new point which may come up tomorrow. This is what is the beauty of the subject. Every new day you can have a new issue. So never feel like this, that sir ने ऐसा छोड़ दिया और हमने ये पढ़ा नहीं. See, even if you are clear about 90% things, I think you have more than enough knowledge. So you don't worry about 10%, 5%. I have told you even in the beginning, because many people are concerned about this कि एक सवाल छूट गया, सर ने ये नहीं पढ़ाया, तो ये वाला टेंडेंसी थोड़ा सा ना हम लोगों को चेक करना पड़ेगा. Because even if I teach 100 of hours on a topic, now 100 of hours on a topic, it is not going to solve all the questions. So you will have some questions left. So please don't worry about that. Don't worry about that. So there will be confusion in your mind, there will be some query in your mind. When you will become a judge, when you will become a high court judge, when you will become a Supreme Court judge. If everything is settled beforehand, then why an issue will be raised before Supreme Court? And why Supreme Court will raise a new issue? See, many cases which go to Supreme Court frames a question and Supreme Court answers it de novo. It has not been settled earlier. So Supreme Court has been established in year 1950 till 2021. It has not been able to establish or settle those questions in 70 years. So how can you do it in now 70 classes or 60 classes? It is not possible. So please try to understand the logic behind this statement, that even if I teach you now variety of points in a particular topic, even then one or two topic may come up. And for that we'll try to find out the answer. You cannot have ready answer of all the questions all the time. So you should not be worried about that. But see, there are three kind of people. It is generally said, one who starts the work and abandons the work at the outset. मुझसे नहीं होगा. तो वैसे लोग जीवन में कुछ नहीं कर पाते. बहुत लोगों की टेंडेंसी होती है, they will never start a work properly because they have this feeling that I can't do it. So you will fail because you never accepted the challenge. There are second kind of people who will start, who will go halfway and then they will leave. Like many people will come in the class and they will leave class halfway. And they will basically allege themselves or their teacher or the system. Something will happen with them because they want to run away. So they will make some allegations either against themselves. Most of them make allegation against themselves. Sir, मुझे नहीं समझ में आता. अरे आप तो इतने competent हो. You are so competent, you can understand anything. You have to just realize this question. Nobody comes from other planet. Everybody is here. And you will remain here. We are here and we will do wonders here. And then there are third kind of people. Whatever be the situation, he or she will fight. He or she will fight and they are the winners. ऐसा नहीं है कि when I studied CPC for the first time I understood everything. I did not understand everything. I understand very few things. I must admit. I understood very few things. I could not understand CPC at all. But now I think that CPC is a journey. It's a story. And if anybody picks this story, then they will be very comfortable in this journey. Now, of course, there will be some hiccups, there will be some hurdles, there will be some stops, there will be some resistances in the journey. There will be sometimes there will be landslide. Sometimes there will be flash flood. Sometimes roads will be very bumpy. So this happens in journey. This is going to happen in CPC also. It will happen in all the subjects. Why to worry? It's a natural, normal phenomena. So to curse yourself that I do not understand and to allege your teacher that he is not able to make me understand or I have problem. No, we should not do that. Rather, we should try to find out the solutions. So let us be part of the solution rather than be part of the problem. If I do not understand anything, I will try my level best to understand it and to make you now comfortable on that particular point rather than running away from that point. So that is not advisable at all. So this is my preliminary advice to you. Please take care of yourself. Don't run away. Don't be misguided. Don't lose hope. Don't lose heart. Let us be calm, cool, patient, and let us be disciplined. First, you understand the theory. I think that you have many questions in this CPC material, which you find that the questions are very big. And you may be disturbed by the fact that how I will solve these questions if you have not been exposed to such kind of questions before. Though in many universities, big questions are asked. But if you are not habituated to it, If you are not accustomed to it, you will have problem. So please do take care. Don't worry about that. It's just question of application. In 10, 20 problems you may find difficulty, but the moment you do 20 problems, 21 onwards, you will have no difficulty. I think that you know how a person learns driving of a car. First day you sit on the car, you do not have idea where is the accelerator, where is the brake, where is the clutch. Even if the now trainer will teach you A, B, C, accelerator, brake, clutch. But sometimes now you will press brake for pressing clutch, sometimes you will press clutch for pressing brake, and you may meet an accident also. It happens when you learn a car. But do you lose hope? If you lose hope, if you lose heart, then you will never learn the car. And nobody can make you learn the car unless until you sit on the driving seat. So you will have to solve the questions yourself. Obviously, I will be sitting on the side seat. But you have to take primary responsibility. That is what is expected of you if you want to do wonderful in your life. Otherwise, we are living like general mortals, and we'll be living and we'll be now finishing after 70, 80, 60, 90 to 100 years. Nobody will remember us. So that should not happen to us. That should not happen to us. Now, I have many problems, I have many difficulties. Today I think that whole morning I studied CRPC. I got up at 7 around and I studied CRPC, I think at least for 3-4 hours. That consumed my lot of time, and then I did not feel very good for the whole day. I had headache and I had problem, then I slept for some time, and then I got up and I just saw the watch, it's class time, so I moved here. I was not feeling well, even then I have come here because I have to perform my duty. Whatever the capacity I have, I must be at my seat because it is question of my students. So that commitment should come from all of us. Many of you are very committed, very energetic, very enthusiastic, but some of you may not be. So please don't worry, let us give time to ourselves. We will have some way, we will have solution in the future. If you lose hope, you will never have solution. Problem and complaint is not the solution. The solution is application, the solution is perseverance, the solution is patience, the solution is rereading, the solution is doing more and more questions, solution is reading more and more, discussing more and more, looking into more and more cases. Solution is not running away from all those things. अब जैसे मैंने 10 केस डाला, मैंने 9 ही पढ़ा, एक आप पे ऊपर छोड़ दिया, तो अब आप कहोगे एक ये भी पढ़ा दो, तो आपके माइंड का नाउ ट्रेनिंग नहीं होगा. So please be careful. You are required to take some responsibility. You all are senior students. You all are intelligent students. I hope that you will appreciate that you are intelligent. If you have belief in yourself, then only you can do wonders. So believe in yourself. What happened in the past, leave it. Leave it. You may not have performed in the past, it doesn't matter. I have seen people failing in matric examination, not doing great in matric examination, that is 10th examination. They have got second division and they have done wonderful in life. And there are many people who have been gold medalist and always topper, they have done nothing in their life. So it's just question of application of yourself. Many of universities are opened by the people who have been contractors whole life. They have never been now educated properly. So this is always question of your determination and commitment. So determination is key. You should not lose hope at all. That's not fair. If I lose hope, I will never learn. So why to lose hope? I know my energy level is less today. I know that I have not been able to study properly today, but I am not going to lose hope. In examination it will happen that certain topics you may not have read well, but you know little bit, so write that. I said order 2, rule 2, if a question is given, you have read so many things on order 2, rule 2. We have covered almost all points. I cannot claim absolutely that I have covered 100% but we have covered so many points which is sufficient for writing a beautiful answer. Sir, application में problem है, होगा. Have patience, we'll do it. So I hope you understand that. So my question is, can you write men's? अब ये बताओ मुझे एक और बात, मैंने आपको बहुत सारे sections and orders ये नहीं समझ में आया, ये क्या है? दीपक यदुवंशी, क्या चाहते हैं आप दीपक यदुवंशी? क्या कहना चाह रहे हैं? क्लास तो चल ही रही है, आपको कोई समस्या है? क्लास चल तो रही है ठीक से? तो इसमें सर प्लीज डू एनीथिंग, आई हैव टू डू नथिंग, यू हैव टू डू यही मैं समझा रहा हूं। देखिए डिवाइस में आपके प्रॉब्लम और आप मुझे कह रहे हो सर प्लीज डू समथिंग। इट हैपेंस, इट्स एन इलस्ट्रेशन, इट्स एन एग्जाम्पल that we never look to the real problem. We always try to put the problem on the other side. It may be I and it may be you. अब मुझे कह रहे हैं कि प्लीज डू समथिंग, व्हाट कैन आई डू, and that too in group. So this is what is the problem. I have been trying to discipline all of you, and I have tried to make you learn that discipline is key in your learning, and avoid writing in chat box all these trivial things. Please contact the technical team. You have all the numbers, you have been told about that, but even then you are interested in writing in chat, so that's your desire, discretion. I can't help all, I can only advise all. So let us move further. So I said, I have given you an overview of entire CPC. I told you on the very first day also that how this CPC is organized, and I hope you understand all those points. I hope you understand all those points. So let us come to the new topic. As much as we can do it today, we'll do it today, and whatever is left, we'll do it tomorrow, and then we'll move further. Little better. So let us see this now. I said now plant is drafted. Now plant is drafted. So the moment plant is drafted, what will you do? अब आप क्या करेंगे? अब आप क्या करते हैं आप बताइए? प्लेंट तैयार हो गया, तो प्लेंट तैयार होने के बाद यू विल फाइंड द कोर्ट वेयर द प्लेंट इज टू बी प्रेजेंटेड. This was the view in Order 7, Rule 1 also. We said the court name, the party's name, if the party is minor or unsound, then the reference of that fact, then cause of action, then jurisdiction, then relief, question of limitation, question of valuation, all these things have to be taken care of in plant. So now, once you draft the plant, you have drafted the plant. We'll take some question on drafting of plant also, don't worry. I'll come to the questions. My idea is that you be little comfortable in CPC, then we'll take up the questions. That is my idea, and it requires little bit maturity. So now you have drafted the plant, now you move further. Now you are moving further. Is this clear? You move further. After filing the plant, there will be further hurdles. Now what is the hurdle? So we'll have to find, you have to find, just try to understand the court of competent jurisdiction. The court of competent jurisdiction. You cannot approach any court and every court, the court of competent jurisdiction. Now, before reaching to the court of competent jurisdiction, you are required to appreciate or you are required to ensure that this suit is a civil suit. Because if it is not a civil suit, how will you move to a civil court? Because civil court doesn't have jurisdiction in other matters. So first ensure, this is the first hurdle, that it is a civil court. Then you ensure that it is a civil court. Then you ensure that the court has jurisdiction. Just understand, these are all very commonsensical things. The moment I say that the court has jurisdiction, I am referring to two ideas. One is pecuniary jurisdiction, another is territorial jurisdiction. As far as question of pecuniary jurisdiction is concerned, it has a reference to section 6 of CPC. As far as territorial jurisdiction is concerned, it has a reference to section 16 to 20. And at the same time, section 15, which says that you go to the lowest court, court of first instance. But before that, you are required to ensure that it is a civil suit. If it is a criminal matter, if it is other matter where civil suit cannot lie, then can you bring it in civil court? The answer is no. So my question will start from here today. What is a civil suit? Or when a suit can be said to be civil suit? Now, to answer this question, all of us are required to refer to section 9. Section 9. Now, once you see section 9, you will be clear about this point which I am referring to. Section 9 is first section in part 1, which is suits in general, jurisdiction of the courts and res judicata. Suits in general and jurisdiction of the courts and res judicata. Courts to try all civil suit unless barred. This is the marginal note. The court shall, subject to the provision herein contained, have jurisdiction to try all suits of a civil nature, excepting suits of which their cognizance is either expressly or impliedly barred. So, section 9 is a very clear-cut mandatory provision which mandates that the courts shall have jurisdiction to try all suits of a civil nature. Courts shall have jurisdiction, excepting suits of which their cognizance is either expressly or impliedly barred. So, बहुत simple सा direction है. See, this section 9 is basically answering the question that where there is a right, there must be a remedy, and if there is a remedy, then there must be proper forum or authority to approach to obtain that remedy. So, ubi jus ibi remedium. So, section 9 is manifestation of that fundamental principle of civil jurisprudence or legal jurisprudence, that wherever there is a right, there must be a remedy. And obviously, remedy is dependent on knocking the door of proper forum or authority. So, that is what is mandated in section 9, and that is why the language is prescriptive and mandatory. It prescribes, it mandates the court. The court shall try. It is a direction, it is a dictate to the judicial tribunal that it is your obligation, it is your duty, and even otherwise you know about jurisprudence. If I have a right, generally you have a duty. There are very few and far absolute rights and absolute duties, where there is no corresponding duties or rights. But generally, right and duties are jural correlatives. If I have a right, you have a duty. If you have a duty, I have a right. So, if I have a right to obtain the remedy, court has a duty to provide me a relief. or remedy. So this is what is being said, the court shall try. Shall, not may. Court shall try, or court shall have jurisdiction. For what? To try all suits of civil nature. Now the question arises, what is this suit of civil nature? What is the suit of civil nature? All suits of civil nature, exception is there. Suits of which? Accepting suits of which their cognizance is either expressly or impliedly barred. Accepting suits of which their cognizance is either expressly or impliedly barred. Expressly or impliedly barred. Accepting suits of which their cognizance is either expressly or impliedly barred. So, the law is very clear on the point. It says that the civil court will try all suits of civil nature. So, question is, what is this suit of civil nature? Because we are not having any question regarding now. Court is judicial tribunal which adjudicates a dispute and decides your legal rights and remedies. So, this explanation is not required to be given. And jurisdiction basically deals with, or jurisdiction can be explained in terms of authority or the competency or the power to adjudicate a dispute which is of legal character or legal nature. So, jurisdiction is also not required to be explained, it is understood. It is power or authority of court to decide or adjudicate a dispute. So, that is not the question here basically, but you should know generally. The question is, what is suits of civil nature? And question is accepting suits of which cognizance is either expressly or now, which suits cognizance is either expressly or implied. So, section 9 basically raises twin questions. It raises these twin questions, and these twin questions have to be answered. And this is what is the journey of section 9. So, we will try to understand this, and then there is explanation 1 also. Let us raise the question first, so that our understanding can be better and will take less time. A suit in which right to property or to an office is contested is a suit of civil nature, all right. So, it explains, explanation 1 explains that what is suit of civil nature. A suit in which a right to property or office is contested is a suit of civil nature, notwithstanding that such right may depend entirely on the decision of questions as to religious rites or ceremonies. So, explanation 1 explains what is suit of civil nature. So, this is the answer. This is one answer of that question. A suit in which right to property, a right to property doesn't need any explanation. Suppose now I have this property and you contest my right to this property and you say it is not your property, it is my property. So we'll prove title, I will prove title, you will prove title, and you will show that how did you get this property and I'll show how did I get the property. So that is how we'll contest this dispute or contest this right, and we'll prove before the court, and court will adjudicate this dispute and court will give a final verdict on the point. So nothing great in this. I claim a right to one property and you also claim right to that property. So obviously we'll bring now some document or some now evidence in our favor, and the court will look into the matter, and then the court will finally adjudicate the dispute and court will say it is whose. So that is what is civil suit. And right to office, whether I am entitled to this office or you are entitled to this office, this is also a civil suit. So right to property or right to office is a civil suit, that is clear. Explanation 1 explains. Notwithstanding that such right may depend entirely. So even if it is dependent entirely on decision of a question as to religious rites or ceremonies, there may be many rites dependent on religious rites or ceremonies. A marriage may be dependent on some ceremony. Earlier even succession was, or even now adoption was basically a kind of religious ceremony. I am giving very simple example, I am trying to communicate an idea that the point is very simple. So even if it is dependent on religious ceremonies, suppose I say that I am the head priest of this particular temple which is taken care of by a particular trust, and for that post there was a requirement of performance of certain religious rites or ceremonies. So now whether those religious rites and ceremonies have been performed to make me head priest or not, that is a question. But my primary question, principal question is whether I am entitled to the post of head priest or not. But it is dependent on religious ceremonies or religious rites. So even if it involves that proof of religious rites or ceremonies on which my entitlement to that post of head priest is dependent, but my primary question is whether I am entitled to the post of head priest of that particular temple which is taken care by a particular trust, that is the question. So my basic point is that I am entitled to this office, though this entitlement is dependent on religious rites and ceremonies. That is another question. So principal, primary, main, substantive question is right to office, which is dependent, which is incidental question, which is auxiliary, which is ancillary, that whether that particular religious rites or ceremonies have been performed to make him entitled to this office, that is a subsidiary question. So if principal question is question related to office, then that question still remains a question of civil nature, a suit of civil nature. So this is what has been explained in explanation 1 in very simple language. We'll explain it little further, but just I am reading the question. So now here is a question. Here this is the question. This needs explanation. This is the third question. That what is the meaning of this expression? देखो कोई भी टॉपिक यदि हम कहते हैं ना हमें समझ में नहीं आया, तो let us understand little bit that this is due to the approach which we are adopting. If we now there cannot be any dispute that right to property or right to office is a civil dispute or civil suit of civil nature. But what is the meaning of this particular expression, notwithstanding that such right may depend entirely on the decision of question as to religious rites or ceremonies? What is the meaning of this expression? That is what is to be understood. So we'll try to understand, don't worry. Explanation 1. Now explanation 2. And then we'll go and answer one by one all those questions. अब आंसर राइटिंग में भी यही करेंगे. We'll do the same in answer writing. So answer writing is not a big thing. It's not a big thing. You must understand. For the purposes of this section, it is immaterial whether or not any fees are attached to the office referred to explanation or whether or not such office is attached to a particular place. So fees is attached or not, it is immaterial, whether he gets certain thing out of that office or not, or whether or not such office is related to particular place. This was substituted by Act 104 of 1976. 1976 CPC has been amended. It is a clarificatory provision. It is immaterial. It does not raise any question as such, but it is clarificatory. It is immaterial, यानी ये एक तरह से आपको चीजें और स्पष्ट करता है, इसमें कोई संकल्पना नहीं है. It is immaterial whether or not any fee are attached to office referred in explanation or whether or not such office is attached to a particular place. So two things are immaterial, that is, this is clarification, this is clarificatory. Fees attached or not, whether or not fees attached, or whether or not it is attached to a particular place. So fees and place are irrelevant criteria. So in sum and substance it can be said, fee and place are irrelevant This is irrelevant criteria. Irrelevant criteria. This is clarificatory. Whether you get a fees or not, or whether it is related to a particular place or not, that's immaterial. We'll explain it a little further, but this is what is being said here. So nothing great in this sense. Nothing great in this sense. So now let us go further. So let us answer the first question first. So whenever you get a question on section 9, you have to raise these questions, primarily the 3 questions and this clarification. So 4 things have to be brought in answer of section 9. आपको हर चीज की क्लैरिटी होनी चाहिए. आप लिखो what is suit of civil nature number 1, what is express or implied bar, number 2, number 3, if it is question related to right to property or office, it is a civil question. Notwithstanding the fact that it is related or it is dependent on entirely religious rites or ceremonies. What is the meaning and understanding of this third expression? And last but not the least, clarificatory point. So one who understands that in answer of section 9, I have to explain these 4 points, he or she will write a beautiful answer. Obviously, you are required to now fill your answer with some important cases, etc. If you know it. If you do not know, that is not going to be suicidal. But if you know, you write this. So let us understand and write little bit also. आप लिखेंगे भी और समझेंगे भी. तो सबसे पहले सिविल नेचर का क्या है और now write down on this point. पहले भी हमने बताया होगा आपको. Civil and nature. when a suit can be said to be suit of civil nature. So question is, when a suit can be said to be suit of civil nature. Basically emphasis on civil nature. So answer is, you write down. Civil refers to private rights and remedies. Civil refers to private rights and remedies. Civil refers to private rights and remedies. Civil refers to private rights or remedies. And civil rights are the rights. Civil rights are the rights. Civil rights are the rights which we get by virtue of being a private person. Which we get by virtue of being a private person. Which we get by virtue of being a private person. Which we get by virtue of being a private person. Which we get by being a private person. You must be knowing that you have both rights, private rights and public rights. The same right will become public right when it is protected by state, when it is guaranteed by state. I might have told you earlier also, but let me tell you here as well. I have a right in my property which is civil right. You have seen in explanation 1 also. So I have every right to protect my property. If anybody trespasses on my land, I can file a civil suit for civil trespass. I can file a civil suit for civil trespass. But the state can prosecute him for criminal trespass as well. So the same interest in my property, when it is protected by me as a private person, is a civil right. But same interest, if it is taken care of by state, then it becomes public right. And how it happens, see, that I am an individual, I am a private person, I have every right to protect my rights. But I am subject of a state also. So a state has also a duty to protect my interest. A state has a duty to protect my interest. So when a state has a duty to protect my interest, then a state has given me guarantee that, see, you are my subject, so I will protect you. The moment you become subject of a state gives you a guarantee. देखो ये सब्जेक्ट और स्टेट का एक प्रकार का अंडरस्टैंडिंग है, एक एग्रीमेंट है जिसको हम लोग पैक्टम सब्जेक्ट्स कहते हैं. ये आपके सीपीसी का विषय नहीं है. आई एम सेइंग इट इवन अदरवाइज that when you become part of a state, when you become subject of a state, then there is an agreement between you and a state. Implied agreement is there. A state gives you guarantee of protection and you give a state surety of obedience. So you say that I will abide by, and a state says that I will protect you. Don't worry. State आपको protection की guarantee देता है और आप उनको कहते हैं कि हम आपको आपकी आज्ञा का पालन करेंगे, आपके law को मानेंगे. तो भाई आपका इंटरेस्ट स्टेट का भी इंटरेस्ट है, बहुत सारे इंटरेस्ट आपके स्टेट के इंटरेस्ट है, बिकॉज स्टेट ने आपको गारंटी दिया कि मैं आपको प्रोटेक्ट करूंगा. स्टेट हैज गिवन यू गारंटी ऑफ प्रोटेक्शन, सो स्टेट हैज टू टेक केयर ऑफ दैट फैक्ट. So state gives you guarantee of property, guarantee of protection against any encroachment or any interference with your property also. And that is what is chapter 17 of IPC. So if anybody trespasses on your land, he will be alleged of civil trespass and you can file a civil suit. That is civil right. But that can become criminal when you can prove, that see there is criminal offense also. And how will you prove criminal offense? For bringing criminality in the case there is a requirement of mens rea. आप दिखाओगे कि साहब ये जो trespass किया है मेरे land पे, it was to cause annoyance, nuisance or to commit an offense, something like that. Then only you can prove criminal trespass. In that case, state will also come in picture and state will punish him. So that right which is available to you as a state subject is public right. We are not concerned with that. हम सिर्फ आपसे इतना करें, आई एम सेइंग ओनली दिस मच, दैट योर राइट एज एन इंडिविजुअल, एज ए प्राइवेट पर्सन इज अ सिविल राइट. So your right to protect your possession, to protect your property is a civil right. And if there is any trespass, any encroachment on that possession, on that property, then obviously you can file a civil suit. So that is what is being said here. Civil rights are the rights which you get by virtue of being a private person. Now, तो सिविल तो आप थोड़ा बहुत समझ रहे हो. ये नेचर क्या है? What is this nature? What is this nature? नेचर क्या है? What is this nature? What is this nature? What is this nature? So on this point you can write down, nature refers to fundamental quality of a thing. Nature refers to fundamental quality of a thing. Fundamental quality of a thing. Nature refers to fundamental quality of a thing. If a suit is fundamentally or essentially, if a suit is fundamentally or essentially, if a suit is fundamentally or essentially civil, fundamentally or essentially civil, then it can be described as, suit of, civil nature. Then it can be described as suit of civil nature. Then it can be described as suit of civil nature. Suit of civil nature. जैसे रेवेन्यू, टैक्स, ये सब सिविल नेचर में आ जाएंगे. Company. So this is larger, broader family of civil. Why we use this expression civil nature? It is just to broaden the horizon of civil suit. Like revenue matters, tax matters, company matters, industrial matters. ये सब civil in nature हो गए. Right to property, right to office, तो है ही civil suit. बट टैक्स का मैटर, इंडस्ट्री का मैटर, रेवेन्यू का मैटर, ये भी सिविल नेचर का मैटर है। सो सिविल नेचर इज वाइडर इन कंपैरिजन टू सिविल प्रोसीडिंग्स। जानबूझ के लिखा है हमने। सिविल तो हो गया प्राइवेट राइट्स। I have written in your material also on page 20, you can look into that. So civil nature will refer to revenue, tax, company, etc., etc. So ये सिविल नेचर का सूट है। अब जरा आप ध्यान से देखिए, in your material page 20, if you can look to the page 20 of your material, I have given 7 examples of suit of civil nature, rather 10 examples. And I have given 5 examples of suit not of civil nature. So you can just quote them in your notes. You can just quote them in your notes. Now we'll raise further question in this. What is suit of civil nature and what is not? But I just stop for 5 minutes here. Very short break. Just you note that example. Then I will explain further. So I just said that if you see examples on page 20 of your material, you find that contract is specific relief, marriage, conjugal rights, right to share. These are all, now contract is a private right, clear? Contract is a private right, is this all right? Marriage, private matter, conjugal rights related to that, right to property, right to worship, everything is your own affair, your personal matter. ये सब आपके पर्सनल मैटर, कॉन्ट्रैक्ट हो, स्पेसिफिक रिलीफ हो, मैरिज हो, कंजुगल राइट हो, राइट टू शेयर इन ऑफरिंग हो, राइट टू प्रॉपर्टी हो, राइट ऑफ वर्शिप हो, टेकिंग आउट ऑफ रिलीजियस प्रोसेशन हो, रेंट हो, एवरीथिंग. This is all related to civil. I hope this is very simple. कोई डाउट करेगा क्या कॉन्ट्रैक्ट सिविल है नहीं है, स्पेसिफिक रिलीफ सिविल मैटर में मिलता है, क्रिमिनल में मिलता है, मैरिज सिविल है, कॉन्जुगल राइट्स सिविल है, ये आपके पर्सनल मैटर से रिलेटेड है, मैरिज से रिलेटेड है. सो दीज आर ऑल सिविल, नॉट ऑफ ना सूट फॉर अकाउंट, सूट फॉर रेंट, किसी को प्रॉपर्टी दी है, रेंट लेना है, तो ये सब सिविल मैटर है. दीज आर एग्जाम्पल्स. तो आप ये एग्जाम्पल्स लिख लिए होंगे, आई होप सो. Now, suit not of civil nature, suit involving principally caste question, purely religious right, suit for upholding mere dignity, suit for recovery of voluntary payments or offerings, suit against expulsion from caste. Now see, why I have given these 5 examples here, I must tell you. Now, the question arises that purely, now question is, now within this point you can write down, you can write further on civil nature. You write down further in this question, that is how the clarity will be there. But religious, political, social matters, religious, political, social or other similar matters, मैं आंसर के फॉर्म में लिख रहा हूं इसलिए बहुत ब्रीफली लिखेंगे. रिलीजियस, पॉलिटिकल और सोशल मैटर्स cannot be brought within suit of civil nature. Why it is said, I tell you. Court says that there are certain matters, which are better to be left out of 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 civil dispute and better to be decided by people of that group or community, better to be decided by people of that group or community, people of that group or community. For example, I give you certain illustrations. And this law is based on the reasoning, that civil court is court of law, not of religion. This law is based on the reasoning that civil court is court of law, not of religion, not of caste, not of politics. Not of caste, not of religion, not of politics. ये court of politics नहीं है. Now if you ask me a question, who will be better Prime Minister? Narendra Modi or Mr. Ranjan? How the court will answer such question? It's unbelievable. It is the people's choice. Modi ji is such a stalwart that he is loved by many million, many billion people. I am not aware of myself that whether I am loved by million or billion, I am not aware. It may be, I don't know. Or it may not be, I don't know. So it is people's choice. Court cannot enforce such things. Court cannot adjudicate such thing. Court cannot give it's not a legal question. It's a political question. Who should be Prime Minister? Let the people of country decide. Because it's a question of their prerogative, their franchise, their right. So now, similarly, if you are not invited to a caste dinner, man-pan invitation, or you are not invited in a congregation of that particular caste, can you raise a question of ostracization? Ostracization. That मुझे इन्होंने बाहर कर दिया. Neglect, ostracize, keeping somebody away from the group. Ostracize, बाहर कर देना, group से हटा देना, अलग थलग कर देना, something like that. Ostracization. So can you allege against that community that it has ostracized somebody? No. If you are not invited to a caste dinner or man-pan invitation, you cannot question that. Because it is prerogative of the people of that community. Similarly, you cannot demand a right to be given religious honor. There was a case, now this point has been asked in your examination in Vanama. Ramanuja Iyer. No, not Iyer, Jeer. Nambi. So, Vanamalai Ramanuja Jeer versus Ranga Ramanuja Jeer. This is AIR 1961, Supreme Court decision. Now, in this case, a suit for mere declaration of mere declaration of religious honor Is this clear? This is a mot. Vanamalai Ramanujajir versus Sri Rangana Ramanujajir. Supreme Court of India decision. If you want to read it, you can read it, that's your choice. It's a long decision. So in this case, the court said, a suit for mere declaration of religious honor, a suit for mere declaration of religious honor, a suit for mere declaration of religious honor is not maintainable. A suit for mere declaration of religious honor is not maintainable. You might find a question where it is said that you please carry me in a palanquin, palki jisko kehte hain, you carry me in a golden palanquin. I have right to be taken in a golden palanquin. So that question arose that whether it is a civil suit, the court said no. Mere right or mere declaration of religious honor is not maintainable. Mere declaration of religious honor is not maintainable. So what is maintainable? Now here on this point let me clarify. You have read this explanation 1, no? So let us revert to that. So write down by changing the paragraph. But if in a suit principal question principal question, principal means pradhan, not PLE. It is always, many people write it wrongly. A principal question. But if principal question in suit is of civil nature, where adjudication involves incidentally determination of caste. But if in a suit, principal question in suit is of civil nature where adjudication involves incidentally determination of caste or religious rites or ceremonies, then that is suit of civil nature. Then that is suit of civil nature. Just to make you understand this, I must tell you that there may be a case where there is a head priest. You can write down the example. For example, head priest of for example, head priest of a mutt may have certain privileges. Head priest of a mutt may have certain privileges. Head priest of a mart may have certain privileges. Head priest of a mart may have certain privileges. Head priest of a mart may have certain privileges. Head priest of a mart may have certain privileges, and that privileges may be dependent on 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 religious rites or ceremonies. Religious rites or ceremonies may be dependent on religious rites or ceremonies. But in essence it involves, but in essence may involve, but in essence it substantially involves question of office. But in essence it substantially involves question of office, that related to this office, this is the right. That related to this office, this is the right. So if it is a purely religious, political, caste question, purely, then it is not suit of civil nature. But if the religious question, political question, social question, whatever it is incidental question, and the main question is related to office, then that is a civil question. Like जैसे आपने कहा कि being head of this mutt, I am entitled to this privileges. So this is basically question related to office, that you are the head of the mutt. Though it may be related to, or it may relate to religious question, and that is why I am entitled to this particular thing, that I am entitled to do this particular worship, I am entitled to certain privileges. I am entitled to certain honors related to that office, then that is not purely religious question. Then that is question related to that office. But if you just say that I have or I should be given this religious honor and this religious privilege without having an office, then that is not allowed. So principal question should be a civil question, meaning thereby it should be question related to right to office, right to property. I hope you understand little bit what I am saying. So principally we have tried to answer the question, what is suit of civil nature? What is suit of civil nature? Civil nature. Civil court is not court of religion, not court of politics, not court of caste. It is court of law. It is court of law. And why we use this word civil nature? So civil nature is used in contradistinction to criminal. Nature I have said about fundamental quality of a thing. अब एग्जाम्पल्स ऑफ सिविल नेचर आपने पढ़ा, इज दिस क्लियर? अब एक केस आया, अब इसी से रिलेटेड कोई कोई केस आया, जैसे एक केस है पीएमए मेट्रोपॉलिटन, दिस इज गिवन इन योर बैरेक्ट ऑल्सो, वर्सेस मोरन मार मार्थोमा. Sorry. PMA Metropolitan versus Moran Mar Marthoma. AIR 1995, Supreme Court 2001, PMA Metropolitan versus Moran Mar Marthoma. Now what is question was whether the court can decide the validity of excommunication of a person from a religious order or not. It was held to be a suit of civil nature because person was deprived of his right to worship, which is civil as well as fundamental right under the Constitution of India. So you can write down excommunication of a person from religious order, excommunication of a person from religious order which entails excommunication of a person from religious order which entails serious consequence, both religious and civil, excommunication of a person from religious order which entails a serious consequence, both religious and civil. Entails serious consequences, both religious that he is not in that religious order, so obviously he cannot perform all those religious rites and ceremonies as part of that order, and obviously civil because he will not be allowed to worship, etc. So if it is so, if excommunication has resulted into violation of his right to worship, like a right to worship. Now obviously right to worship is a civil right. So I said excommunication of a person from religious order which entails serious consequences, both religious and civil, like right to worship. Then it is a suit of civil nature. 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 Both religious and civil, like right to worship, then it is a suit of civil nature. Is this clear? It is a suit of, why it is a suit of civil nature? Because it obviously impacts your right to worship. Moran, PMA Metropolitan versus Moran Marthoma. Is this clear? Now then, Satyarth Prakash versus Usman Ghani. Satyarth Prakash versus Usman Ghani. I hope this case is given in your material also, no? This is page number 21. Satyarth Prakash versus Usman Ghani. Can you see page 21 of your material? Page 21 of your material. Satyarth Prakash versus Usman Ghani. Page 21 of your material, please. This is decided in 2008 by High Court of Delhi. The question was basically whether civil court can entertain a suit for banning or issuing an injunction on publication of work which is in existence and being published and read for last 135 years on the ground that its publication was likely to disturb public tranquility and public order. So what is the issue? The issue is whether civil court can entertain a suit for banning a publication which has been printed for last 135 years, or can it entertain a suit for injunction to restrain its publication which has been in existence for last 135 years on the ground that it has tendency to disturb public peace and tranquility. Is this clear? Is this all right? So this is the question. Now, this is filed by two public spirited person, and they have objection, or they have basically raised object of protecting religious feeling of other persons of the same religion, seeking a declaration that publication and distribution of Satyarth Prakash, written by Swami Dayanand, was injurious to religious faith of Mohammedan community. So their submission is that publication of Satyarth Prakash is injurious to the feelings of Mohammedan community, and that is why it should be restrained from publication. Now question is it a suit of civil nature? Is it a suit of civil nature? That is the question. The court explaining this law of section 9 explained everything, and then they said, can you see this judgment in your let me bring the judgment here. Now here I am reading this para 4. It is evident means clear, that every court while entertaining suit must be cautious that it should entertain only those suits which are of civil nature and have characteristic of affecting one's right of civil. Where no civil right or monetary loss or any function of plaintiff connected with his civil rights have been affected, the court should not entertain a suit nor should fall in a trap of allowing somebody to use it as a tool for public disturbance. Now here, putting restriction on religious books or banning publication of certain work involves constitutional issues and cannot be entertained by civil courts and can be raised only by way of writ petition. Taking cognizance of the matters of religious nature where no civil right are affected is fraught with danger. So that is the apprehension of the court. Today, two persons from Muslim community have filed this suit for banning Satyarth Prakash. Tomorrow, another two persons from any other community may file a suit for banning the Bible, the Quran, the Gita, or such other religious books, which are revered by one or the other section of the society. It is not the province or the duty of the court to pronounce on the truthfulness of religious tenets or reasonableness of the contents of religious book or to regulate the religious sentiments and feelings of the sections of the society. This is the relevant operating paragraph. A suit by Hindu against the Quran or by Muslim against the Gita or Satyarth Prakash claiming relief of permanent injunction are likely to arouse or injure the religious feeling and disturb peace and harmony, are in fact meant to play mischief in the society, and by filing such suits plaintiff would get nothing but cheap publicity and create some more disharmony and disturbance in the society. So rather than banning the publication, it is entertaining the suit which will create all problem. The question involved in such kind of suit are not of civil nature and are purely of religious nature in section 9. Purely of religious nature, involving rights under article 25, not 225, it is 25. This is wrongly printed. So just correct it, it is 25, not 225. 25 of the Constitution of India. So article 25. Constitution of India and article 25 talks about that. And I must tell you that furthermore, the civil court in this case ignored the fact there are specific provisions under law in respect of banning of books, and section 95 CRPC confers a power on a state to declare certain publication forfeited if it appears to state that any matter was in violation of provision of IPC as mentioned in that section. Under section 96, High Court could set aside such declaration of forfeiture made by the state. So this is the reasoning that see section 95 of CRPC can be invoked. Article 25 Constitution is relevant. And for this you could have filed a writ petition rather than bringing the matter here. A writ petition could be filed, could have been filed. So when you read cases, you must develop this art of writing relevant points now. So this is what is the crux. No civil suit. No civil suit. I hope you understand. It is purely religious question. You can write this side, purely religious question. No civil suit in section 9. Satyarth Prakash. This matter cannot be decided by a civil court. It is not the province of court or a duty of court to pronounce on religious or truthfulness of religious tenets. It is not duty of court. Rather, if we entertain such petition, that is going to be harmful to the society. Purely religious question, no civil suit. No civil suit. No civil suit. No civil suit. भाई इतनी बात आपको समझ में आ गई। अब देखो इस मैटेरियल में भी this point is written. If you see your material, question number point number 4, Article 25, such types of expressly barred, Section 95 CRPC. Can you see point number 5? Point number 4, Article 25 Constitution. Point number 5, Section 95 CRPC. And then this mischief in society. And you can add that this is not suit of civil nature, it is purely of religious character. See, on caste question also it is written in your material further. Just for example, you read this, that as regards a matter relating to caste, it would be relevant to state. As regards a matter relating to caste, it will be relevant to state that when a person is expelled from the caste, it involves his legal right and he can move to court for declaration that he should be readmitted to caste and that he is also entitled to damage on expulsion from the caste. The right to remain in community or to exercise the rights and privileges of the member of community is a civil one. This is a civil right. The suit would lie as a civil suit would not lie when a person is deprived of a social privilege such as expulsion from caste dinner. अब caste से बाहर कर देंगे ना किसी को, तो that will entail consequences of deprivation of his civil right. How? He cannot marry person of his caste. In India, intra-caste marriage is very much prevalent. So if you expel somebody from caste, can he or she marry a person of the same caste? No. So that entails civil consequences. That is why the suit will lie. But if I do not invite somebody in caste dinner or man-pan invitation, that is caste dinner, now in that case, or right to assistance in removal of dead body or contribution of fund on marriage occasions, in that case no civil right is violated. But if I remove, like now I removed you from a religious order, and if it entails civil consequences that you cannot worship a particular deity or particular community, then that is a civil dispute. Similarly, if I remove you from caste and you are not allowed to marry a person of the same caste, it will entail civil consequences, of course. And right to remain in community is also your right. That is also your civil right. But right to be invited in caste dinner, right to get contribution for marriage, these are not civil disputes. So in that case, we will not entertain civil suit. In that case, we will not entertain civil suit. So political question, political question, caste question, religious question. Is this clear? So I stop here for the day because I will take this express or implied bar tomorrow. So I will start from here tomorrow with this express and implied bar. And we'll start solving question of section 9 itself first. थोड़ा थोड़ा क्वेश्चन को लेना शुरू करेंगे, slowly and steadily. We'll first solve section 9, then we'll solve jurisdiction, then we'll come back to plant questions. We'll solve plant questions also after doing this topic of jurisdiction. So first I am going to take the question of section 9. Section 9, please read it and try to solve the questions. I will also solve the questions tomorrow. And then I will go to jurisdiction of section 16 to 20. Then I will solve the question of section 16 to 20. And then I will take the questions of plant also. Is this clear? No, I'll be okay tomorrow. I feel little exhausted today due to certain disorder in body. It may happen with anyone. I am having headache also, and I am having some unrest in body as well. I am not comfortable, but I will be okay. I hope so. Nothing grave, nothing great. So I will start questions from tomorrow, and I'll start with section 9 first. I will teach section 9, I will take up question of section 9. So please be ready with the understanding of section 9. You also read it, I will also do it. Don't worry. And then I will do section 16, 15 and till 20. And then I will do question on jurisdiction of section 16 to 20. I will not leave any question unanswered. If you have any issue, you can start writing question. You can write questions in group also, write questions. एक ने लिखा है, आप में से किसी मैं वो जवाब दूंगा वो सेक्शन 11 पे कोई क्वेश्चन, सेक्शन rather order 7 rule 11 पे you have written one question. I have seen one case. You have found out some kind of discrepancy and I have to clarify that. I will do it. You can write question in group. Question has to be written from 9 a.m. to 9:30 a.m. and 9 p.m. to 9:30 p.m. Only 2 time. Not every time because it is quite disturbing. WhatsApp group. Excommunication means where you remove a person. Excommunication. Remove a person from a group, that is excommunication. Excommunication means where you remove a person from a group. Asim Singlab, you understand? Excommunication means removing, ostracization. Excommunication from an order, आप हटा देते हैं किसी को. कोई भी क्वेश्चन हो आप ग्रुप में लिख दीजिएगा. 9 PM to 9:30 PM, 9 AM to 9:30 AM. सुबह में आधे घंटे, शाम में आधे घंटे. जो भी क्वेश्चन हो प्लीज राइट योर नेम ऑल्सो. प्लीज राइट योर नेम ऑल्सो विद द क्वेश्चन. Please write your name as well with the question. You write your question and write in the end your name also so that I can address it to you. ठीक है, नहीं है जब, बट जो मैंने आपको बताया वो आपने समझ लिया ना. अक्षत कुमार जी, कहीं भी मिस्टेक हो सकता है, मैं पेज की बात नहीं कर रहा हूं. क्लैरिफाई सर मैंने कर दिया सर. मैंने आपको बताया कास्ट क्वेश्चन पे, पेज 21 को पढ़िए ध्यान से, इसमें क्लैरिफिकेशन क्लियर है. मैंने आपको पेज में क्या लिखा है उससे मतलब नहीं है ना, पेज तो जस्ट रेफरेंस है। जो मैं बता रहा हूं आपको समझ में आ गया? व्हाट आई सेड यू अंडरस्टूड? आई सेड, अब बहुत जगह बहुत कुछ लिखा हो सकता है, लॉ हमेशा इमर्ज करता रहता है, नहीं लॉ चेंज भी होगा। सो आई सेड excommunication from caste which results into civil consequences where your right of marriage can be at receiving end and it may be affected. So it is a question of civil nature. But not inviting somebody in caste dinner is not a civil question. यहाँ clarified है, here it is clarified, page 21. एक्सपल्सन फ्रॉम कास्ट, अब देखो एक्सपल्सन फ्रॉम कास्ट डिनर, अब समझ रहे हो, एक्सपल्सन फ्रॉम कास्ट डिनर है यहां पर बेसिकली, एक्सपल्सन फ्रॉम कास्ट डिनर ऐसे समझ लो ना। पेज 20 पे इट इज सूट अगेंस्ट expulsion from caste dinner or exclusion from caste dinner. So there can be little bit controversy here and there, so don't worry about that. But what I explained on page 21, that should be clear. मैं भी लिख लेता हूं, मैं भी करेक्ट करा दूंगा इसको, डोंट वरी। थैंक यू वेरी मच फॉर पॉइंटिंग आउट। तो मैं कल एक्सप्रेशन, आप एक धुला भाई का केस है उसको पढ़िएगा, धुला भाई का केस, धुला भाई वर्सेस स्टेट ऑफ एमपी, इफ यू कैन रीड इट, धुला भाई वर्सेस स्टेट ऑफ एमपी। इसको ऐप में दे दो, धुला भाई वर्सेस स्टेट ऑफ एमपी, यू सेंड इट इन ऐप, इसको ऐप में भेजो, धुला भाई वर्सेस स्टेट ऑफ एमपी। कल हम लोग पढ़ेंगे केस गुंडा जी सतवा जी शिंदे वर्सेस रामचंद्र भीखाजी जोशी, ऑल्सो दिस इज सुप्रीम कोर्ट, धुला भाई इज ऑल्सो सुप्रीम कोर्ट। So we'll read these cases tomorrow.